IP is not a value in itself. IP, intellectual property, is actually a tool for economic development. The real question is not what happens when a robot autonomously invents. The real question is, to what extent do we still require human contribution? We are very far from any kind of normative work as far as AI is concerned. This technology is so rapid that it's very difficult to actually follow it with the policy. The IP system needs to remain relevant if we want to keep it. And if it becomes obsolete, then why maintain it?
Welcome to Talk IP to Me, where we sit down with IP professionals, founders, and legal minds to share stories behind the work, some practical lessons. And today I'm joined by none other than András Jókúti, the Director of Patent and Technology Law Division at WIPO, the World Intellectual Property Organization. Before joining WIPO in Geneva, András served as Director General for Legal Affairs at the Hungarian Intellectual Property Office, but also worked across several ministries and universities and tech hubs as an IP legal advisor, and has been closely involved in all European and international patent law and policy. András, welcome to the podcast. Thank you so much for accepting our invitation.
Thank you, David. It's a pleasure to be here.
How would you introduce what you do and your team does at your organization?
I think a good way of putting it, without being boring at all, is to say that we are actually working with member states, both as a community and both on a bilateral basis, to help them build their own IP systems and also to contribute together to the progressive development of the international IP system. The four pillars of our activities, I think, explain very well what WIPO is actually doing. So the first one is communicating about IP so that it is reachable and accessible to everyone everywhere. It's communication awareness raising. The second pillar, addressing the global challenges as a community with member states and doing the normative work that WIPO is doing, making treaties or soft law or guidance, but something where the international community is coming together to tackle these emerging issues. The third one is those global registries and databases and platforms and infrastructure that WIPO is providing, such as the PCT, if we stay in the patent area, which is a global system to facilitate actually for businesses to navigate the IP system. And the fourth one is engaging with all kinds of stakeholders to empower them to use the patent system. So this encompasses those advisory activities that we have with the member states relating to legislation and policy, but it also covers universities, SMEs, and all those stakeholder groups that need some kind of a support from WIPO to be able to use the IP system as it's intended to be used.
That sounds like it's very much of a human position where you communicate with a lot of different people, with a lot of different cultures, with a lot of different mindsets. How does your team cope with the challenges that comes with this sort of mindset challenges that are in the industry?
I think for the general audience who wants to hear more about what WIPO does, a more important aspect is how do we deal with a diversity of the IP ecosystems within the different member states, and how do we take into account the different levels of development and the different economic priorities that the member states are having when we are assisting them or when we are organizing any event that is supposed to be to the benefit of the member states. We are not offering one-size-fits-all solutions. I know that this is an overused term, but this is something very important, that any advice that we are giving on a bilateral basis to a particular member state, when they're coming to us, to my team, for example, to advise them on how to build up their patent system, for example, in the legislation, we are not giving them something that we would give to another country. So we are engaging in a conversation with them. And I would really like to see ourselves much more as a coach, like a life coach to the country in the field of patent law, than a teacher. So we are not trying to teach them what to do. We are not trying to impose on them something that they should be doing, but we are presenting them the different policy options that they're having. And when they need further assistance in drafting their law, for example, then we are providing them with a little nudge, with a little assistance, with a little sample provision, but we are never telling them what to do. And this really needs to be anchored in their level of economic development and what are the patent law policy choices that work in a country similarly situated to them. So we always have to make a comparative analysis and the deep analysis of what they are facing right now and what are their international obligations at the moment and what kind of flexibilities they can operate with when they're building up their system.
Okay, so if I understand it correctly, you said the international legal framework You give them examples and benchmarks and give them free consultancy in a sense. And then it's up to the country who actually decides what to implement in their legislation.
Right, that's correct. But let me clarify that what I was explaining now and what you were following up on was the legislative and policy assistance kind of service that we are providing to them. And you are very right. We are basically giving free advice to the member states because that's one of the functions of this international organization, to be at the assistance of all the member states that are coming with these requests to WIPO. So when we get a request like this, it's very important to have the proper project scope. Many times, the initial request only comes as a very broad, high-level ask for, like, update our patent laws, for example. And it's very difficult at that point to understand what exactly do they need and what is the motivation behind it. We are not solving their problems. We are engaging in a discussion with them, in a dialogue. And imagine a coach when somebody comes to them at their office with marital problems. I mean, the coach or the therapist will not tell them what exactly to do to save the marriage. They will say, there are these techniques, and tell me more about what you're encountering at home and what are your main concerns and where do you think that the bond is lacking. And then the therapist or the coach can actually give very useful advice that they can actually go home and exercise. And maybe this is a little bit of a silly example, but it works similarly with the member state. We are not trying to tell them that this is the patent system that you are supposed to be having. We are saying, what is it that you actually want to achieve with it? This is a very important message for WIPO, that IP is not a value in itself. IP, intellectual property, and the patent system in general is actually a tool for economic development. It's a tool, it's a business asset for companies, it's a reward system to encourage innovation in the country, and it operates a little bit differently in different types of economies. So the United States of America will not have the same patent system and not have the same needs for a patent system compared to a country in Southern Africa, for example. And you really need to identify those needs and identify the policy room, the room for maneuver, where they can make that selection. But we have to understand them first, and only after that we can give advice.
I think the therapist analogy that you brought is just such on point. It helps me at least understand a lot more about there's a lot of diagnosis going into this process. And then once you understand what's happening and what they actually want, then you can give them tools and advice on how to achieve their goals. What you described sounded like someone coming to you asking for advice. But then one of the industry's current challenges is, of course, the rapid technological development and changes in the macroeconomy and, of course, the environment that we are living in. So what happens when, for example, AI lands on the table? And there are 194 different countries with different economical levels and development in terms of IP infrastructure. Does WIPO do anything to sort of help with an overall strategy?
I mean, AI is definitely a huge development that just landed on everybody's table. And IP, of course, is just one aspect of it. Or I would say that AI, the impact of AI is one aspect of what the IP system needs to deal with in the context of policy development. It is something that actually prompts a lot of policy development, or at least policy discussions. But it's also interesting and important at the same time to see that what WIPO, what the Secretariat is doing, has to be asked for by the membership of WIPO, not just on a bilateral basis that we saw previously, but it has to be the member states that are bringing a project to WIPO so that the organization can help with that. Now, when we talk about AI, it's a very big topic, and its impact is different on the different forms of IP that WIPO is dealing with. But everybody knows that the copyright system is already quite heavily challenged by the emergence of AI, especially with the latest developments in generative AI. But the impacts of AI on the patent system are somewhat less obvious. So I think if we want to zoom in a little bit in the patent area, we can see three fundamentally different angles that we need to look at. The first one is when the inventions upon which an applicant is seeking patent protection involve AI or some kind of an AI system or AI model or AI tool is part of the invention itself. It poses substantive patent law questions that the system needs to be able to answer. And these patent law questions are subject matter eligibility. To what extent can an AI tool be considered as a software? How is the invention being characterized as a computer implemented invention? Is it still eligible for patent protection under the different regimes? How do you grasp that aspect of it? but also questions such as sufficient disclosure, which is a fundamental requirement under patent law, that the patent applicant needs to explain and disclose the invention in the patent application to the extent that the person skilled in the art can actually reproduce and do the invention. Now, when it comes to an AI-based invention, it is a big question. How much do you actually have to disclose about the training data, about the training methods? Is there some kind of a black box that you cannot disclose because you are not even aware of it, what's happening in that black box in the AI's mind, so to speak? And these are things that are challenging the patent system from the inside, because these are substantive patent law issues that are being featured a little bit differently when it comes to an AI-based invention. This was the first big thing that we see. The second one, and that's probably gaining the most notoriety, is the role of AI when it's an AI-assisted invention. Now, famous Davos cases where the applications are featuring a robot, if you like, as the inventor, are actually pushing it to the far end of the spectrum, and it's much less characteristic. And we also consider it a little bit as a red herring. The real question is not really what happens when the robot autonomously invents. The real question is, to what extent do we still require human contribution, and what is the right threshold of human contribution so that an invention still attracts patent protection? And this is a policy question already, because in these scenarios, we are considering co-inventorship with an AI system. And we don't have to go necessarily in the direction of science fiction and imagine that, some kind of a conscious or sentient being is trying to come up with new solutions on their own initiative. It's rather the use of AI tools, and the more and more prominent use of AI tools, questioning whether this boon that the patent system is representing, this incentive, this economic reward, is still warranted if the degree of human intervention or human contribution is lessening with the growing of the contribution of the AI systems. And this is where a very fine policy line should be drawn. And this is where the conversations are also heading, not what happens when a robot autonomously invents, but rather on this delicate balance between the co-creation with an AI system. So this is a second big pillar of policy discussions that we are having. And of course, the third one is looking at this issue from the perspective of the IP offices themselves. When the IP offices are trying to leverage the power of AI to be able to administer the patent system. So they're using them for classification, for prior art search, for fee monitoring, or for chatbots to customer service applications. And all these new features or new services or new tools that they are using are also powered by AI. So this is a very interesting thing, that you're using AI to administer the system that is supposed to be encouraging innovation, which already has a big chunk of AI embedded in it, both on the side of the inventorship and also from the side of being part of the invention itself. So this is how all this is woven together.
That seems so fascinating. And it sounds like this discussion has been ongoing for a few years now, and all of these topics have relatively been thought through. What can you tell us? How far are we from an overarching AI legislation in the WIPO countries? Or how far are we from sort of agreeing as member states on what to do with it?
I'm laughing not because the question is silly, but because what I explained really shows that there is a lot of thinking that has gone into it. At the same time, we are very far from any kind of normative work as far as AI is concerned. And there are basically two explanations to that. One is that the emergence of this technology and the development of this technology is so rapid that it's very difficult to actually follow it with the policy. And we have seen that the EU is trying, to establish some kind of regulatory framework around AI, not necessarily the IP element, but in general, governance of AI. But already we see that 1 or 2 years after its adoption, there are already tweaks that need to be done. And the international community as a whole, imagine 194 member states, it moves much slower than this. And, treaty making can last for, 10 to 20 years or sometimes even more. So the question is whether actually an international treaty is the right tool to tackle this issue. Now, of course, it's not for the Secretariat to determine this. The member states can always decide to convene and agree on a treaty, but that's not the direction that I'm seeing that it's going. Discussions are important, sharing experiences are important, having the policy issues identified are important, and maybe finding some common benchmarks, some guidance that everybody can subscribe to is very important. but an international agreement with binding force would be a bit of a stretch, and we don't really see an appetite also from the member states to engage in that kind of a normative work. So when you are asking how close are we to some kind of a consolidated, I don't know what was the word that we were using, AI law in this area, I would say we are very far from that. But if you're asking it in a more optimistic manner, or a question that attracts a more optimistic answer is, how deeply engaged are member states in discussing these matters, then I can say that quite deeply, because this is something that occupies a lot of policymakers and a lot of governments' mind. And allow me to draw your attention to a very important aspect, and this is the divide between the developed and the developing world. And I see that the concern of the developing countries is, and it's a justified concern, that whichever direction the policy discussions are taking the international community, it should actually not enlarge but diminish the technological gap between the different regions. And it's important that this emergence of AI and its impact on the patent system, which is an incentive system, I'm never getting tired of emphasizing that, is not making the divide even bigger. So any policy in this regard should not be premature. So the international community shouldn't jump the gun, because we need to find a solution that not only the most industrialized countries can subscribe to, but also the developing countries, for which the patent system also has to yield benefits.
So did I get that right? So developing countries see AI as perhaps a leapfrogging opportunity for them to sort of get closer to the industrialized countries or the developed world?
I would say that it's an uncharted territory, but for an industrialized country with the right capacities and, of course, the innovation potential that they hold, this is a frontier area where they see, of course, more opportunities in terms of economic development. But if you take a developing country, or for instance, a least developed country, where even the most basic patent administration tasks are posing a challenge, then obviously there is some anxiety there, saying that if the technological divide between these two, let's say, tiers of the countries with different innovation potentials are growing, then it's not even worth to have a patent system, because they will never be able to catch up. Which doesn't mean that innovation in this field should not be encouraged by way of the patent system as such as well. But it's very important to also show to the developing world how they can also leverage AI to have an efficient system in place, and also to enable their innovation, their local or domestic innovation ecosystems, to maybe leverage the power of AI, because AI innovation is sometimes less resource intensive. I'm not talking about environmental resources, because sadly it is very resource intensive. But like a mathematician or any kind of an engineer can leverage AI, and you don't necessarily have to have clinical trials like in the pharmaceutical field. And those countries can also have a system that is fostering and helping the domestic innovation system to grow.
One thing that you have been referencing quite many times throughout this conversation is intellectual property as a tool to incentivize innovation and, of course, inventive technologies. And there is a quite successful project that I know you have been part of, the Standard Essential Patents, or SE. And I was really wondering, what was the incentive behind creating the system?
Well, WIPO didn't create the system of standard essential patents. It's a phenomenon that has been there for decades. What is new from our perspective is that WIPO is getting engaged with this very special field of patent law, which has very close neighbors such as competition law, standardization, and some others. So what I would say is that there was a realization that there is a very specific area within patent law where there is no international discussion really going on. There are national, regional, industry-driven conversations around standard essential patents, and they have been there for such a long time. But WIPO, even though it's a UN specialized agency for intellectual property, including patents, has never really been very active in this field. And one reason for this was that whenever it came up in the Standing Committee on the Law of Patents, there was no overwhelming support from the community of member states to actually tackle this area. And even today, we can see that the regulators, the policymakers, are somewhat reticent, with the exception of some notable countries and regions, to actually address issues around SEPs, or standard essential patents. But the industry and the litigation in this field is much more prominent, much more active, and it really showcases the tensions that are present in this field. But I think to bring this down a little bit to the earth, it's good to explain what we are really talking about. So what I was just explaining until now, why WIPO is getting engaged in this, and why do we have a strategy now, and why are we deploying certain initiatives in this area. But for the audience, maybe it's also interesting to understand what are standard essential patents, right? The easiest way to break it down is just to see the three words that this term is composed of. Let's start with standards. Standards are these technological platforms, these technological specifications that are being agreed on within standardization or standard developing organizations, such as ISO or ETSI, or I could name a lot of others, ITU, IEEE, and so on. So there are these standardization organizations which have different kinds of memberships, but many of them have industry memberships. So the industry players are sitting down around the table and they are agreeing on a technical specification that makes a certain technology or a certain aspect of a technology work together. This is interoperability, and also ensuring certain safety standards. And these standards, I mean, very good examples of this are, 4G, 5G, Bluetooth, Wi-Fi, and these are just the connectivity ones. But there are also standards for video streaming, compression, and many other fields. So you can see that these standards are pervasive throughout our lives, and we couldn't even necessarily make our devices talk to each other or operate together without the existence of these technological standards. Now, it's important to see that when the industry players are agreeing to these standards, they're also baking into this cake some of their own raisins, if you like, or cranberries. I prefer those to raisins. And these cranberries or these raisins are the patents that they own to certain components of these technological standards. So they're bringing their best technology to the table and say, if we want to build the new standard around 5G or 6G now, then I'm also bringing this technology that was developed in my shop. But you have to understand that it was a lot of investment from my part to come to this technological solution. So obviously, I obtained a patent on it. This is how the patent system operates. I'm investing and I'm getting this economic benefit of a limited type of exclusivity for some time. So I'm willing to give this to the community, but you have to know that this is proprietary, so you will have to license it from me if you want to be using the standard, if you want to manufacture something that is compliant with the standard. And this is where the third part, the essentiality, comes into play. We call those patents standard essential patents that you really have to use in order to be compliant with the standard. Which means that if you look at the standards for Bluetooth, for example, if you want to build a device that has Bluetooth functionality, you will use a lot of inventions, and they are talking about hundreds, or in the case of certain standards, thousands of inventions that are patented by others. So this means that you have to seek a license. But there is another side of this equation, because if the patent holder would be in the same position like they were without this essentiality, they could charge any price. And they could select who they want to license this piece of technology to. But when they are subscribing to this standardization process, they have to make a commitment that they will license their patents to anyone who wishes to be compliant with the standard, so to anyone who needs this access, on fair, reasonable, and non-discriminatory terms. So they have to make this commitment, and they cannot just charge any amount of money, but that amount has to comply with this standard of FRAND, fair, reasonable, and non-discriminatory. And this is where most of the disputes are coming from, because it's easy to say that you have to be friendly with each other, but at the same time, nobody really tells you what are those license rates or royalty rates that comply with this requirement. And this is where the parties, on the one hand, the SEP holders, the contributors to the technological standard, and the implementers who wish to be compliant with the standard, are in tension with each other, because they need to agree on the licensing terms for the usage of these standard essential patents. Let me just tell you what WIPO is actually doing in this area, because we are not the ones who are adjudicating about what is the FRAND rate, but as you can imagine, there are different disputes that are being settled differently in the different parts of the world. So it's very good to create some kind of a global platform to understand each other. And even though WIPO, or the International Bureau, is not going to be prescriptive, we are launching several initiatives that are contributing to this discourse. First, of course, we are holding events, we are organizing workshops, symposia, and so on to create this platform for global dialogue. But we are also publishing a lot of resources that are enhancing the transparency in this area, because that's a common complaint, that it's very difficult to say which patents are truly essential and which are the ones that are only declared as such. And of course, there is great obscurity about the licensing terms that the companies are agreeing on between each other. So it's very difficult to draw a comparison with other licensing agreements when you are negotiating the license bilaterally, two companies I'm talking about now. So there is a lot of transparency deficiency around this field, and we are trying to dissipate that fog a little bit with the tools that are at our disposal. And this is where, for example, we are grouping a great amount of information gathered from standardization organizations and also from patent pools into our global patent database, which is called PatentScope, so that there is a one-stop shop for this kind of information. Now we are filling up, this empty vessel right now as we are garnering more and more collaboration from the different stakeholders. But this is a transparency measure that we are very proud of. Of course, WIPO also provides services in the alternative dispute resolution area. So we do provide mediation and arbitration. That's not my division, but the Arbitration and Mediation Center. But that's also a very important pillar of this strategy. But these are just examples of what types of activities WIPO is doing to alleviate some of the difficulties or the concerns around standard essential patents. But it is not something that you can solve overnight. And we are only one international layer to this, which is only complementary to what regional organizations, member states, or the companies or their own associations are doing on their own behalf.
I think one of the main pieces of news that I'm always seeing about SEPs is, companies going to court and giving different terms to use their standard essential patents. And it popped up just recently on my feed, something that's called the WIPO Mediation Pledge. Can you tell me a little bit more about what that does?
Right. So mediation was already on the menu. The Arbitration and Mediation Center already offered that, and we have a lot of resources to make sure that everybody can craft their contractual relationships in a way that they can subscribe to mediation, which WIPO can also provide. The pledge, a voluntary commitment from a certain set of SEP holders, that when it comes to a small or medium-sized enterprise in the Internet of Things area, then the first resort will be mediation instead of litigation. So this pledge is just a commitment from the side of these currently only 5, but we are hoping for more to join, these 5 companies, to say, if you're an SME, you don't have to be afraid that we, as the holders of these patents, will sue you, because if we approach you, the first thing that we can do to resolve this dispute is going to be mediation. And we will also bear 2/3 of the cost of the mediation, so we will get a bigger share of the cost of that process. Now, this is not something that will immediately change a lot, but this is a very good reassurance from the side of the SEP holders that they are not going after SMEs. And even if somebody gets on their radar using the patents that they should be licensing if they are standard compliant, they are not going to be faced with some kind of a mega lawsuit somewhere, which they could never afford and which they could never fight. So this kind of mediation pledge is a reassurance so that SMEs in the Internet of Things area can enter into this field with a little bit more of a peace of mind.
So as I understand, this is exclusively right now for the Internet of Things field, right? Yeah. But I assume it's in the plans to perhaps talk with other SEP holders in other fields to encourage more SMEs to use their standards.
Well, and as I said, the offering from the Arbitration and Mediation Center is constant. So mediation and arbitration is available in any case. But yes, it would be great to see the expansion, both in terms of the holders that are joining this initiative and also in terms of the material scope of the pledge.
Let's imagine a future where WIPO succeeds with these pledges. Companies, especially SEP holders, become cooperative and transparent. So let's say more mediation will become a norm in 5 to 10 years from now instead of litigation. What does that future look like for you?
Sorry for always laughing at your questions. I'm not really laughing at the questions themselves. It's just sometimes they're very utopistic. So I don't think that alternative dispute resolution is something that brings some kind of a utopia, it's a very useful thing to avoid litigation because it comes with a lot of efficiencies that litigation doesn't have. It also has its downsides. Confidentiality, for example, is often mentioned, which is an advantage for the parties, but it's a disadvantage for the sake of transparency. What I think is not just mediation that brings the paradise on earth, but it's rather, the summation of a lot of initiatives that are making the whole playing field a little bit less contentious, where the FRAND rate is something that is not disputed so much because there is a transparent economic rationale behind those licensing fees, and where the disputes are not characterizing the area, it's rather the deals, the actual licenses that are being concluded that are more characteristic, and litigation is only a couple of outlier cases. Now, mind you, a lot of the SEP holders are already saying that if you look at the statistics, there are much more deals that have been concluded bilaterally than actual litigation. It's just that the litigation news are making the headlines, but the commercial reality is that most of the disputes are actually handled between the companies, maybe not by way of third-party mediation, but just by way of successful licensing negotiations. So I think less disputes is something that would be great, because all the resources should not necessarily go into lawsuits, but rather actual innovation and the manufacturing of those products for the benefit of the consumers.
Thank you so much for that. My very last question before we moving on to the last part of the interview is, tell me two things. One that makes you very optimistic about the future in IP, and one that quietly worries you.
The fact that in the last 2 years, there were 2 international treaties that were concluded in the field of intellectual property makes me a little bit hopeful to think that maybe multilateralism is not dead. Of course, we see a lot of tensions nowadays, and geopolitics are definitely not fun in these months. But if you see that the member states of WIPO could actually get together, and despite all the differences, they could agree on the adoption of 2 international treaties in recent times, that gives me a bit of hope. Not necessarily hope to have an international treaty every year. That's not the goal. The goal is to maintain the conversation and not to close off all the dialogues and the constructive discussion. We do still see the vestiges of those at WIPO, and that gives me hope. On the other hand, what fills me with anxiety is not necessarily the emergence of AI per se, but AI was shedding a lot of light on how vulnerable the IP system can be to something that is so new. And I think we have to realize that the IP system needs to remain relevant if we want to keep it. So we don't have to keep it relevant so that it remains as a system. It's not something that we have to have. But if we want it to have all those beneficial impacts that we want it to have, then we have to be able to adjust it by measure of the technological development. And what fills me with anxiety, to come back to your question, is whether in this political climate, it is still possible to get to agreement on fundamental things that would keep the IP system fit for purpose. Because if it's not fit for purpose, it will create dysfunctions. And if it becomes obsolete, then why maintain it? So our responsibility at WIPO, and this is the community of member states, not just the Secretariat, is not just to maintain the system, but also to keep it fit for purpose in the face of all the technological developments and all the geopolitical tension.
Thank you so much for that, András. And with that, we would move into the second part of the conversations, where we call this rapid fire questions. I will just throw a few questions at you, and I just want you to don't overthink it. Just say what's on top of your mind. And it can be a word, a sentence, or even just an expression, and all will be related to IP, except for one. So are you ready? Okay, so the first one is, one IP policy myth you would like to retire forever.
I think it's what I mentioned about the Davos case. There is an IP policy myth that really have to look at the robots autonomously inventing, and this is what will break the patent system. It's not that.
One international WIPO initiative that you're personally really proud of.
I think it's the standard essential patents strategy and the work that we are doing there, which is very novel. It involves a new set of stakeholders, if you like, and types of activities that WIPO hasn't been doing before. I'm very happy with that work stream.
I can really understand. That's a huge step into a better future. And the very last question comes from our last guest, who asked, what is the best way to approach AI to help build innovations, in your opinion?
What I was trying to do during the conversation was to break it down to issues that really deserve special consideration. So instead of talking about it as a whole and just say, oh my God, AI does this, AI will destroy that, or AI will, bring us the best things in the universe. I think it's always important to really break it down to intelligible and compact issues that you can afterwards really deal with. I think that's the most important thing, because any kind of generalization will not bring anybody closer to any kind of solution.
Thank you so much for that, András. This has been a really fascinating conversation. I really thank you for taking the chance to talk with me today, share your knowledge and your experience with the audience, and also to give us a glimpse on how actually WIPO works and what initiatives are there to frame the IP industry into a better future. And to everyone else listening, thank you for tuning in today to Talk IP to Me. And if you enjoyed this, please feel free to share it with a colleague or a like-minded person who works in innovation, IP, or anywhere else. And we'll see you in the next one. Thank you, András.
Thank you.